Welcome and thank you for joining me today for the ultimate guide to estate planning. Hi, my name is Lynn, St. Louis, and I'm an estate planning and elder law attorney with ELG Estate Planning. We serve clients in Washington and in North Idaho. Now, there are a lot of misconceptions about estate planning, and one of my goals is to make estate planning more understandable, to provide information so that you can act and put into place the right estate plan for you. Because we're in Washington State, most of what I'm talking about will be Washington laws about estate planning. So if you're in a different jurisdiction, if you live, for example, in California, much of what I'm talking about today won't apply to you. So if you are in a different state, please seek out the services of an estate planning and elder law attorney in the state where you live. All right, let's go ahead and get started. When it comes to estate planning, one of the biggest misconceptions is that in order to need an estate plan, you must be a wealthy person. And that simply is wrong. Everyone needs an estate plan, no matter their age or their wealth. What really is important is finding out what your particular situation is. And how would you know? Well, one of the first steps is to seek out guidance. And I am so happy you are here listening to the discussion today, because what that tells me is that you know that an estate plan might be something that is right for you. When it comes to estate planning, typically people that don't have one, they wait until it is too late. The fact that you are gathering up information says that you are interested and perhaps will be taking some action to put an estate plan in place, one that will be right for you, one that will protect you. So when I'm talking about the ultimate guide for estate planning, what we're going to be talking about is what is an estate plan? What are the components of an estate plan? How do those affect you? So let's go ahead and let's get started. When it comes to estate planning, you probably are familiar with a will, and we will be talking about a will. But we're going to first talk about what I call living documents. And living documents are those documents that protect you while you're alive. So maybe you have heard of a durable power of attorney for finances or for health care, or a living will, which is really an advance directive or a health care directive. In Washington, we can use all of those terms to talk about your written directions as to what happens in the event that you are at end of life. Now, why these living documents are so important is that they protect you during your lifetime should something happen to you such that you lose capacity. So if you are an adult over the age of 18 and you want to make sure that you are protected if something happens to you, if you're in an accident or if some health condition occurs, you need to have in place your durable powers of attorney. So let's talk about those. Why is it called durable? The reason that the term durable is used is that if you lose capacity, that document you signed remains in effect. It stays in place. The authority under the durable power of attorney continues. So it's really important that your power of attorney be a durable power of attorney. If it is not, and if something happens to you such that you can't make your own decisions, then the state will step in. The court basically takes over and will make the decisions for you through a court-ordered guardianship and conservatorship. So to avoid having the state take over and make decisions, you need to have a durable power of attorney in place. Now, this is one of the reasons that people don't want to do any kind of estate planning, because in order to think about the need for one, you're saying, well, I could lose capacity. or, something could happen to me. And most people go along in their lives and think, I don't need one. I'm in great health. I'm able to make my own decisions. But see, that's what estate planning is all about, is planning for the what ifs. Because if you plan for the what ifs and put the necessary estate planning documents in place, then you don't have to worry about those what ifs. You've already prepared for those. And if they don't happen, fantastic. But if something does happen, you are protected. You and your family will not be in court in having somebody else make decisions for you. So the durable power of attorney is so important. What is the durable power of attorney? It is the document where you say in writing that if I can't make decisions, I designate somebody else to make decisions for me. Typically, if you're married, that will be your spouse. You also need to have a backup person to that spouse. What if you and your spouse are both in that same car accident and both of you are incapacitated? So you want a successor person designated as your attorney in fact, and ideally you want somebody designated beyond that person. So you name the first attorney in fact, a successor, and then an alternate successor. And we recommend that you do not have joint decision makers. We don't want a committee. We want somebody who has the legal authority, somebody that you trust, somebody that you've appointed to take care of your affairs in the event you cannot do so. A durable power of attorney can be for finances and for health, or you can separate out that document so that you have one for finances and one for healthcare decisions. The reason that we at ELG Estate Planning like to have those as separate documents is because our durable powers of attorney are quite comprehensive. We anticipate or try to anticipate every situation and every authority that you might want to include in your estate planning document. And so those documents can get quite lengthy because they are comprehensive. And so we like to separate it out because your finances and talking about your finances is different than talking about your healthcare decisions. Also, sometimes people want to have, for example, their daughter to make decisions for their finances, their son to make decisions for their health care. And so if you want different people to be designated as the person with authority for decision making, having two separate documents, a durable power of attorney for finances and one for healthcare, makes a lot of sense. These documents, these living documents, the durable powers of attorney, are often overlooked. One of the reasons for that is that if people who are preparing estate planning documents, or if they're not elder law attorneys, they often don't have the experience of seeing what happens with incapacity, with progressive dementia, with the things that happen in life. So an estate planning and elder law attorney will rarely recommend to you that you have just a will or just a trust, because that is inadequate. It's extremely important that when you're looking at what is the right estate plan for you, that you have a comprehensive estate plan. I'm not saying a complex one. I'm saying a comprehensive estate plan. And a comprehensive estate plan will include the living documents, especially the durable powers of attorney. The healthcare directive is also a living document in that it is in place while you are alive. That is the document where you say in writing that if you are at end of life, what medical treatment do you want to receive? A lot of people are confused about the advance directive, the healthcare directive, and the living will. Of course, it's confusing. I just used 3 terms to refer to the same document. What it is, it's that document that's in place and says that if the doctors have said you are in a permanent vegetative or terminal condition, then the healthcare directive comes into play. And what happens then? The doctors will be guided by what you have written in that document. Did you say that if you are in that end of life condition that you want all heroic measures? Or did you say that you don't want heroic measures and that you prefer to be given comfort measures, but be allowed to pass peacefully without having been hooked up to equipment and that sort of thing? So the healthcare directive is a very important document. Keep in mind, remember that I was talking about a durable power of attorney for healthcare? The person who is designated under your durable power of attorney for healthcare is what is called your healthcare agent. If you are in a condition that you can't speak to your doctors, your healthcare agent will speak to them for you, and they will express your wishes. Your wishes are written down in the healthcare directive, but somebody needs to express them, and that is your healthcare agent. They will speak for you. In the healthcare directive, it might say you want no heroic measures. If your healthcare agent needs to be the person talking to your doctor and say, no, I don't want, I know that, my mom or whoever it is who they're speaking on behalf of, they don't want that kind of medical treatment. The fact that you have memorialized it, you put your wishes into that healthcare directive, has the effect of giving clarity, but also alleviating any guilt that they might have, because they know what they're doing is they're simply speaking for you as you would if you could. So those are the essential living documents that are a part of and should be a part of every estate plan. And the reason that I start with that is that they are so often overlooked, and in my opinion, that they are so important, that I like to start this guide by talking about these very important living documents: your durable powers of attorney for finances, for health, and your healthcare directive. I also want to mention one of the misconceptions about estate planning is that, who needs an estate plan? Well, wealthy people need an estate plan. Typically that is the biggest misconception. I haven't said anything about whether this person is wealthy or what their assets are. Everyone needs these documents, no matter if they're single, married, their age, whether they have kids, whether they don't have kids, whether they have a house, don't have a house, whether they have a taxable estate or don't have a taxable estate. None of that makes it less important to have the durable powers of attorney and healthcare directive. What I'm saying is everyone needs those estate planning documents. When most people think about estate planning, they think about, well, we're talking about my will or perhaps a trust. What happens when I die? And that is where a person's estate planning documents will start to look different depending on what their situation is. So, for example, if somebody has a lot of property, they have a taxable estate, which in Washington, a taxable estate is $2.193 million. Then their will or their trust might look different than someone who has no home, very modest means. But yet, even though the document and what's in the document might look different, everyone does also need to have either a will or a trust. What these documents do is, on your death, they pass assets to whomever you want to receive the assets. Let's talk about a will. Let's talk about a trust. Let's talk about how they are different. Now, a lot of financial advisors say that everybody needs a revocable living trust. And a lot of those financial advisors are in states other than Washington State. In Washington State, we have a very simple probate process. It is not a probate that is complicated. It is not, fees associated with probate aren't dependent upon what the value of the estate is. It's dependent upon how much work is involved. Other states are different. California, for example, their probate process is very complicated, costly. And in that state, for example, a revocable living trust might be the best way to go for the majority of people. So this is what I want to remind you, that I am Washington-centric in the discussion today. So what is a revocable living trust? That is a legal document that you sign while you are alive. And if you are creating the revocable living trust, you are the grantor, which means, and the trustor, which means you're the person who's creating the document. You are likely the trustee. That means you are the person in charge of managing the trust assets. And if you're married, perhaps you and your spouse are both trustees, you're co-trustees. You're likely also the beneficiary of the trust, as your spouse may be if you're married. Beneficiary means you get all the benefits of all the assets in the trust. And then the trust likely will say where the assets go when you pass away. If you pass first and you're married, your spouse will likely be the person who now is the beneficiary of this trust. And when your spouse dies, then it typically says that the trust assets go wherever you want them to go, which may be to your children, for example, or wherever you want them to go. Revocable living trusts are often misunderstood because with a revocable living trust, you still feel like you own the assets, you're in charge of the assets, you benefit from the assets, and you don't even need to file a tax return because there is no separate tax entity. So with a revocable living trust, one of the problems with them is that once they're set up and perhaps initially funded, after that, they're ignored. And if they are ignored, that's when the problems occur. A revocable living trust is intended to manage the property while you're alive and then distribute it on your death. If the property is not titled in the name of the trust, then the trust does not control it. So, for example, you maybe put your house into the trust with the help of the attorney, and you did a deed to put the house in the trust. So it's titled not in your name, but in your name as trustee of a trust. So the trust is funded now with your house. But what happens if you decide that you want to open up a new bank account and you forget that you're supposed to open up that new bank account in your name as trustee of the trust? If that happens, and it happens quite commonly, then the trust does not control that bank account. So when you pass away, the trust has no control over any assets that are outside of the trust. As a result, and it's very common, what occurs is people will have a probate after their death plus a trust administration. So the whole goal of having the revocable living trust was to avoid probate, but because the trusts are not well understood, or maybe the person didn't seek ongoing legal help to remind them how does the trust work when they die, not only is there the trust administration, but a probate. If you have a revocable living trust, you'll know that you have what's called a pour-over will. Why do you have a pour-over will? Because so commonly assets are outside the trust that there needs to be a will to capture those through a probate, bring them back into the trust so that they can be distributed. I'm not saying that trusts aren't a great idea, revocable living trusts. They certainly can be. It depends on what your situation is. There's no rule that says, yes, you must have a trust, or no, you must not have a trust. What I'm trying to emphasize is that whether or not a revocable living trust is right for you depends on your particular situation. And please don't rely on a financial advisor. See an attorney to find out whether your situation is right for a revocable living trust. And if you do have a revocable living trust as your platform for the estate plan, make sure that you understand it so that it can be operated correctly. Let's talk about wills. In Washington State, I would say more commonly, we use a will platform for where your assets go when you die. There's a lot of benefits to using a will over a revocable living trust. Everybody's heard of a will. You're familiar with a will. What does a will do? A will is how you direct your assets, on your death. What people often misunderstand is they think they have a will, so therefore there will not be a probate, which is exactly the opposite. A will means that there will be a probate if that's how your estate plan is set up. So if you have a will and if you think that you're avoiding probate, please go back and talk to your estate planning lawyer to make sure you understand, does your will avoid probate or not? And we will talk about probate, but I want to talk about the will itself right now. So in Washington, a will has to be executed with a lot of formalities. We need to have a witness. We need to have a notary that notarizes the signatures of the witnesses so that it is a self-proving will. What it means by a self-proving will is that on your death, the will can be filed with the court and nobody has to go into court and say, yes, this is a valid will, because the witnesses have already said that through a self-proving affidavit. And I am getting into detail about the formalities of a will because in Washington, it's very important that all these formalities are followed. So if you have done your own will, you've done an online will, there may be problems with your will. And I'm sharing this with you now because with a will, the problems aren't known until after death, which means they cannot be corrected. If you have a will you drafted yourself or you did it online yourself, or if you have any questions about your will, the way to get answers to whether your will is correct, whether it's executed properly, whether it accomplishes what your goals are, is you need to see an attorney and ask them those questions. A will means that there will be a probate, typically. I will talk about avoiding probate and whether it's the right thing for you. But let's start with the basic, the fundamental, that a will means that there will be a probate. So what is a probate? After the person has died, their will is filed with the court in the county where they lived. Who files it? Typically, it's filed by the person that's called the personal representative, who's been nominated in the will, or the executor. They mean the same thing. There is a petition that has to be prepared because if you're going into court, the court has to know, why are you there? Just filing a will isn't enough. There needs to be a petition to start the probate and to ask that the personal representative be appointed. Assuming that everything looks good with the will, then the executor, personal representative, will be appointed. There'll be an order that starts the probate, and the person who is going to be managing the estate will receive what is called letters testamentary if they are the person who is nominated in the will. If they weren't nominated in the will, then it's called letters of administration. Regardless, it means the same thing. They have the legal authority to act on behalf of the estate, to gather up all the assets, to inventory them, to see what there is, to pay any legitimate creditors' claims and debts, and to give notice to anybody who is a beneficiary or an heir that there is this probate process, and then to ultimately distribute what is left. There are a lot of formalities that go with a probate. Oftentimes people will start a probate on their own and then realize that they need help with a probate. It's not terribly complicated, but it is a legal proceeding, and that is why an attorney is often needed to help make sure that you do things right. One of the things that you want to make sure of is if you are probating a will and you're not getting any legal guidance, realize that you are assuming personal liability if you do things wrong. If you don't file the final tax return or make sure that taxes were paid, then you assumed that liability for the taxes, which, a personal representative is simply trying to carry out the wishes of the person who died. They don't want to assume liabilities. That's one of the reasons having an attorney to help protect the personal representative, make sure things are done correctly, is a really good idea. Yes, with estate planning, with probates, with legal matters, there will be legal fees. There are some clinics where it is actually free. In Spokane at Gonzaga, we do have a legal clinic at the Gonzaga Law School that is free for people who are of a certain age and of very modest means. So keep that in mind. But as a general rule, when you're talking to an attorney, when they are preparing your estate plan, when they are helping with anything, there will be legal fees charged, which is one of the reasons I think that people don't seek out the services of an attorney. But by not doing so, the consequences can be far greater than had they simply went to an attorney, paid for the correct estate plan, the correct probate, and did things correctly. Let's talk about why anybody would ever want their estate to go through probate. Because there are ways to set up and to avoid a probate. I mentioned the revocable living trust route. That is a way to avoid a probate if it's done correctly. In Washington state, particularly when it comes to married persons, if they want to make sure that they leave money for their spouse, one of the best ways to do so is through a will that contains an asset protection trust. Let me tell you what I'm talking about. At ELG Estate Planning, we do estate planning and elder law. We help clients with long-term care issues. We help clients qualify for Medicaid. We have Medicaid expertise. Oftentimes, we will recommend to our clients that if they are a married couple, that they put in their wills what is called an asset protection supplemental needs trust. This is how it works. An example is probably the best way to explain it. Let's say we have a couple and they have $1 million, $500,000 in their house and $500,000 in bank and investment accounts and such. And they are concerned about long-term care costs, rightly so, because the number one threat to any senior's financial security is long-term care expenses. So let's say we have a couple, they're in their 70s, and maybe they don't have any diagnosis, but they know that long-term care is something that they're worried about. So their wills will each contain this supplemental needs trust. When the first spouse passes away, their half of the estate, remember we're in Washington, so it is a community property jurisdiction. So as a general rule, half is owned by one spouse, half by the other. The first spouse dies, their one half of this $1 million is going to go through the will, through the probate process, into the supplemental needs trust for the surviving spouse. What is the benefit of doing that? The benefit is that no matter what happens in the future for this surviving spouse, they will always have protected from creditors and from long-term care costs and from Medicaid eligibility and spend down that $500,000, one half of the combined estate. The deceased spouse's share will be in this trust. Because it's in the trust, it will not need to be spent down before the state will pay for long-term care for the surviving spouse. So to put it into perspective, this couple, one of them dies and the surviving spouse has dementia. And because they have dementia, they will not be able to live on their own anymore. Once their spouse has died, they're going to need to move to a care facility, memory care facility, an adult family home, somewhere where they will be safe. So if that is a situation when the first spouse dies, then through the probate process, what we likely would do is we would take and put $500,000, that is the cash element of the couple's estate, into the supplemental needs trust, leaving the house in the name of the surviving spouse. Under Medicaid's rules, a house is not a countable resource. So the surviving spouse is eligible for Medicaid immediately without any spend down, despite the fact that they own a house that's worth $500,000 and they have $500,000 in a trust. So you may have some familiarity with Medicaid's rules that a single person can only have $2,000. Yes, they can have $2,000, plus they can have $500,000 in this trust. The only way that they can have this $500,000 in trust is if it was created by their spouse's will, not by a trust. A revocable living trust doesn't achieve this result. If this type of asset protection is attempted through a revocable living trust, the state won't honor it. It has to be done through a will. And since it's done through a will, there must be a probate. So yes, there was a will, there was a probate, there were legal costs involved, and there's $500,000 protected. That is one of the reasons that your estate planning and elder law attorney might recommend to you to use a will, to use this asset protection supplemental needs trust. So if you hear the term probate, don't think, oh, that's a terrible idea. Ask the question, why would I be interested in doing a probate? How would that benefit me? There's a lot of other reasons to do a probate, to make sure that there's an orderly administration of the estate. With a revocable living trust, often an attorney isn't involved, so it may not happen that the trust is administered properly. Also, with a probate, there's an easy mechanism to get rid of creditors that shouldn't be paid, that don't need to be paid. With a probate, you're more likely to make sure that if you have a taxable estate, that your credit shelter bypass trust is set up. Let me explain what I mean by that. The federal tax level is over $12 million currently. If that is your situation, I'm guessing you are working with a tax planning attorney, as you should be. For people who are under the $12 million level, you don't need to worry about federal estate tax. If you live in Idaho, you are at the federal tax level. Idaho doesn't have an estate tax, but Washington does. And as I mentioned before, it's $2.193 million, which if your house has appreciated, even if it was very modest when you bought it, but now it's worth, $1.5 to $2 million, you have some concerns about having a taxable estate. So with a couple, there is not a tax imposed on the death of the first. And for that reason, sometimes it's overlooked that on the probate of the death of the first spouse, a tax trust needs to be funded. Now, it can be funded through a revocable living trust, or it can be funded through a will. If it's funded through a will, it's sometimes called a bypass trust or a credit shelter trust. The whole purpose of this trust is to make sure that you take advantage of that $2 million tax credit that your spouse has so that you don't need to pay it on your death. For example, the couple has a $4 million estate. First spouse dies. $2 million is going to fund that bypass tax trust. So when the surviving spouse dies, they only have their own $2 million, which passes to their beneficiaries tax-free, as does the amount that is in that tax trust that was funded on the death of the first spouse. So this $4 million goes tax-free, estate tax-free, to the beneficiaries. If, on the other hand, this tax trust wasn't funded, then the surviving spouse ends up with $4 million. And when they pass, $4 million will be in their estate, of which only about half of it goes tax-free. So there will be a couple $100,000 in unnecessary estate taxes paid, all because the couple didn't understand estate planning or didn't seek out the services of the attorney, or they had a revocable living trust to avoid probate, so they never looked for help when the first spouse died, so they never funded a tax trust that was in their trust, but they never did the work to fund it. And as a result, they're going to end up paying a couple $100,000 in unnecessary taxes. So this is the reason that I think it's really important to share this information, that it is definitely a benefit to have this understanding for long-term care purposes, Medicaid purposes. Whether or not you'll ever use Medicaid, it gives clients a great deal of reassurance and peace of mind to know that no matter what happens, they'll never leave their spouse impoverished, because they'll leave them with this asset protection trust. Or if we are working with clients that have a taxable estate, that there won't ever be unnecessary estate taxes paid. So I started out by saying how important the living documents are. These documents that take effect upon your death, your will, or your revocable living trust are also very, very important. One of the things that I want to mention is that you might hear from, reading online or talking to your financial advisor, that this is the one way to go. This is what you need to do. And what I would hope that I have shared with you is enough information that you feel like you can ask some questions. You can say, why is a revocable living trust best for me? Why is a simple will best for me? When I say that, oftentimes when clients reach out to us, they say, I want a simple will. And I completely understand what they are saying. What they're saying is, I want an estate plan that's right for me, that I can understand. I don't want it to be more complex than it needs to be. So when people say, I just want it simple, what they're saying is, I want the right thing for me, something that I can understand, and I don't want it to be unnecessarily complicated. And they're right. That is what their plan should look like. A will might be the right will for them that has an asset protection trust for their spouse, or a tax trust for their spouse, or an asset protection trust for their adult child with disabilities, or their adult child who has lifestyle issues, or their adult child for whom they're concerned will be going through a divorce, and they don't want the divorcing spouse to get all of the assets that their child would otherwise inherit. You want an estate plan that is right for you, that has the right kind of planning, protections, trusts. And to know what is right for you really means sitting down with your estate planning attorney. I definitely recommend an elder law attorney. Why I do that, in ELG, we are estate planning and elder law attorneys. But why I mention elder law is that a lot of what we do is we help clients plan for incapacity, plan for long-term care, plan for the future. And certainly nobody is looking forward to any kind of need for care or facility-based care or the costs of care. But that doesn't mean you don't plan for it. If you have a plan in place, you're prepared no matter what happens. At ELG Estate Planning, we help clients with how do you pay for your costs of care. Medicaid is a particular area of elder law. It's using government benefits to pay for long-term care, be it at a nursing home or at an assisted living, adult family home, or even in your own home. So having that type of expertise is something that may definitely benefit you if long-term care is something that you are concerned about, regardless of whether there's a diagnosis, regardless of whether you're there at this point or your spouse is or family member is. Just having that plan in place that if anything should happen, if long-term care is needed, you'll want to be working with an attorney who is an elder law attorney who has Medicaid expertise. Okay, let me see if we've got any questions before we wrap up. We will be providing to you an estate planning guide as well. If you have questions about estate planning, and keep in mind that my goal is to provide information to help educate so that estate planning isn't so overwhelming, so that you feel like you have enough information to say, yes, I do need an estate plan. And yes, I will take action to find a guide, to find the right attorney to help put that estate plan in place. I can tell you that when our clients have an estate plan in place, they have this sense of peace, knowing that they no longer have to worry about it, that they have a good idea about what their estate plan is, how it works, and they don't have to worry about it any longer. So please reach out to the attorney in your area, the estate planning and elder law attorney, and get that advice that will give you that peace of mind. At ELG Estate Planning, we do have a lot of resources on our website and on our YouTube channel, and all that information there will be in the chat. If you are in a different state other than Washington and North Idaho, you probably would benefit from finding an attorney who's an estate planning and elder law attorney in your state. How do you find that person? Of course, everybody does their Google research, but there are also organizations such as the National Academy of Elder Law Attorneys. That's NAELA.org. If you go to that website, you will have a list of attorneys who are elder law attorneys who are close to where you reside. Question in the chat here is, how can an LLC work for my second property for asset protection? That is a great question. I didn't even talk about LLCs, so let me just kind of circle back a little bit and talk about LLCs. An LLC is a limited liability company. Oftentimes, businesses are held by LLCs. For example, we are Elder Law Group, PLLC, which is a professional limited liability company. For people with investment properties, real property, rental properties, often those are held in a limited liability company. It is for management of the company, and it is also to help insulate against liability should any accidents or something happen at the property. For example, you have a rental home. The rental home is subject to a fire, somebody is hurt. The LLC is intended to make sure that the person injured can only access the property, the insurance, and the property that's in that LLC. So that was just a very brief discussion of what an LLC is. So an LLC does give you asset protection, certainly, just like insurance gives you asset protection. When I am, and the LLC itself may say whether or not the interest in the LLC passes to somebody else upon the death of the member, or it may say that it passes to their estate. So I'm not able to answer a question about how the LLC will go. It depends on what the LLC itself says. Just keep in mind that if you do have an LLC, your estate planning attorney can help give you guidance that if your LLC says it passes to your estate, then it can go under your will, and then it can go to any of these trusts. Or the LLC can pass outside of your will, pass outside of any other mechanism. It just passes on its own according to the terms of the LLC. It is something to talk to your estate planning and elder law attorney about. All right. Well, I want to thank you for joining me today. And if you have any more questions, feel free to reach out to us. Our website is elgwa.com. Our phone number is 509-468-0551. I'm Lynn St. Louis, and I thank you for joining me. Take care.